Straight ahead on Law&Crime Daily. A no-knock warrant leads to the death of a 22-year-old Minneapolis man. How the city's mayor is reacting.
Making these policies, we have a sacred and extremely important duty to honor the sanctity of life.
Plus,
we have been able to take what we believe is a serial killer off the streets, and had we not done this, we're pretty sure that he would have killed again.
Jury selection begins as accused serial killer Robert Hayes stands trial for murder. And a juror turned witness. Why the famed Scott Peterson juror will take the stand in an evidentiary hearing. But first, chilling testimony in the preliminary hearing for the parents of accused high school shooter Ethan Crumbley.
What was your thought immediately?
My thought was that it was Ethan.
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmeyer along with Terry Austin. A preliminary hearing was held for the parents of the accused Michigan high school shooter. While defense attorneys motioned to delay the hearing, a judge ordered the proceedings continue in the case of Jennifer and James Crumbley. Both are charged with 4 counts of involuntary manslaughter following the shooting spree at Oxford High School last November. Prosecutors say their son, 15-year-old Ethan Crumbley, opened fire in the school, killing 4 students and injuring others. Prosecutors say parents Jennifer and James Crumbley actually gifted their son the weapon that was used in the school shooting and ignored the multiple warning signs from the school, including disturbing drawings made by Ethan and reports that he kept a bird's head in a jar. On Tuesday, defense attorneys argued the hearing should be delayed as the prosecution has been slow to turn over the evidence. The evidence includes some 3,000 pages of materials, 70 hours of video, and 10 hours of recorded interviews. A judge denied that motion. Multiple witnesses testified on Tuesday describing the moments following the shooting and what Jennifer Crumbley asked of her supervisor.
When you heard about the shooting, was it public who was responsible for it?
It was not.
What was your thought immediately?
My thought was that it was Ethan.
And tell me why you thought it was immediate. Your immediate thought was Ethan.
Because I know that they own guns, and I know that they go out shooting, and that manifest with everything written on it made me think that it was him.
After that, then you received the next text?
Yes, I believe so.
And what does it say?
OMG, Andy, he's going to kill himself. He must be the shooter.
And then the next text?
I need a lawyer at substation with police.
And then what else?
Ethan did it.
And what does the text say?
I need my job. Please don't judge me for what my son did.
And what did you think about that?
I was surprised by that text.
Why is that?
I was surprised she was worried about her job at the time. I thought she'd be more worried about what was going on.
Joining us today is legal analyst Kirk Nurmi and Terry Austin to discuss the Crumbley parents' hearing. Kirk, in the hearing, the prosecution had a number of witnesses testify, including a horse farm owner that rode with Jennifer. What do you think she and these other witnesses kind of brought to the table for this hearing?
Well, Brian, ultimately the theme of this case for the state, this hearing, has been that the Crumbleys combined were both bad people, bad parents who ignored the warning signs with their children, with Ethan specifically, because they were busy with extramarital affairs and the horses. And this witness, we saw the horse farm owner that was a friend of Jennifer's. We see that she can kind of tie in some of this talk of extramarital affairs, but she also put some tangibility on things when it comes to the horses. How much money did they spend caring for the horses? How much time did they spend of their time and resources they could have been using to get help for their son? That, and along with, of course, when things came down, the idea of wanting to sell the horse to get the money so they could flee. So it all just wraps in perfectly for the state with their theme that they're trying to present to the court so they can take this case to trial.
Absolutely. Now, Terry, last week the prosecution filed a motion about the defendant showing PDA, or public displays of affection, in court. Is there anything the judge can even do about that, though?
Well, it is a free country, so it might be hard for the judge to control anybody's behavior. I mean, generally, unless it's harmful or disruptive. But I think there's an argument to be made here that that sort of behavior can be at least disruptive, because the attorney basically should be telling his client, listen, you need to focus. This is a serious case. We have 4 people who died. There are others who were injured. And the fact that you are, displaying these affectionate, actions in court absolutely means you're not focusing on this case. You're not being serious enough and you're not taking this seriously, and that can be used against them. So it's not a good idea for them to continue.
Yeah, we'll see how either the judge, prosecutor, or defense attorneys address this and see if it continues on as this case develops. Still ahead on Law and Crime Daily, an accused serial killer finally has his day in court. But first...
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back to Law and Crime Daily. A former juror is granted immunity to testify as convicted wife killer Scott Peterson requests a new trial based on bias and juror misconduct. It all stems from the 2004 trial where Peterson was found guilty for the 2002 murder of wife Lacey and unborn son Connor. Peterson's team says he did not receive a fair trial, alleging juror Rochelle Neese lied during jury selection. Peterson's camp says that Neese, who was dubbed Strawberry Shortcake by the media, did not disclose she was beaten by a boyfriend while she was pregnant. They say that bias is grounds for a new trial. This week, the Stanislaus County District Attorney's Office announced Neese will receive immunity before testifying at an upcoming evidentiary hearing on February 25th. Previously, Neese had said without immunity, she would invoke her Fifth Amendment right. The evidentiary hearing is expected to last about 1 week. After that, a judge will have 90 days to determine whether Peterson deserves a new trial. Let's bring back legal analyst Kirk Nurmi and Terry Austin as we dive into this strawberry shortcake of an issue. Terry, what's immunity in this setting? How does it protect Neese? And if she didn't get it, how would it look like invoking her Fifth Amendment right?
Well, look, immunity means that she doesn't have to be prosecuted for anything she might say. And she could say things that could be used against her here. The fact is, she did fail to disclose, first of all, the domestic violence, but also she had been involved in some legal proceedings. She can talk about that and she can explain why she didn't raise it. And the explanation she has sort of intimated in the past was that she didn't know that this was a legal proceeding and she didn't consider herself a victim. So she can explain that and it won't be used against her. Without the immunity, Brian, she could be held accountable for not revealing that, and she could face some sort of penalty as far as that's concerned. So I think it was smart of her to ask for this and to absolutely get it for her testimony.
Yeah, Kirk, what's a win for Peterson look like in questioning Neese in this kind of hearing?
Sure, I think there's different levels of winning, Brian, because we first talk about her being untruthful during the questionnaire and during voir dire. Because if she makes those admissions, that gives the Peterson team fuel to argue that the trial was tainted. But if it goes further than that, if she says, well, based on that, I wasn't going to listen to all the evidence. I had my mind made up all the way. My experience was consistent with this, something of that nature, that raises the stakes. That makes it harder to deny that the trial was tainted. And in this time of the Olympics, if you will, the gold medal victory is for her to say, I went in there, I didn't have any chance that I was going to acquit this man, and I went into the jury and voiced my opinion, and therefore ultimately tainted the whole jury. And then that would make the quest for a new trial for the Peterson team impossible for a judge to deny under the Sixth Amendment.
Yeah, so using your analogy, Kirk, let's see how the Peterson team does, whether they stick the landing or kind of fumble it here. We'll see as that hearing is expected to come up soon. Thank you both. Coming up on Law and Crime Daily, the death of a 22-year-old AMIR LOCKE, what we know so far about the no-knock warrant that led to his death. Plus, the so-called Daytona serial killer. I'll look ahead of the case as jury selection gets underway. Here at Law and Crime, we cover cases big and small from coast to coast. Occasionally, that means the trial of an accused serial killer. Jury selection began this week in a Florida courtroom for Robert Hayes, whose alleged crimes span a decade. Investigators say he's responsible for the murders of not one, but 3 women. Here's Jesse Weber with more about this case and how a single cigarette butt led police to linking Hayes to several cold cases.
We have been able to take what we believe is a serial killer off the streets, and had we not done this, we're pretty sure that he would have killed again.
Robert Hayes, who's accused of being the Daytona Beach serial killer, goes before a jury to begin his trial for the alleged murder of 3 women, a crime which could lead to a death sentence. Investigators say from 2005 to 2007, Robert Hayes was a criminal justice student at Bethune-Cookman University in Daytona Beach, Florida. During that time, a serial killer terrorized the area. Police believe Hayes is the man responsible. This trial includes charges in connection to the deaths of 3 women, Laquita Gunther, Julie Green, and Awana Patton, who authorities allege were sex workers in Volusia County. It started in 2005 with the murder of 45-year-old Laquita Gunther. Gunther, who was left in a kneeling position in an alleyway partially clothed on Christmas Eve 2005, had been shot in the head, and police had no suspects. Just 3 weeks later, the murder of 34-year-old mother of 4, Julie Green, who was a friend of Gunther's. She was found dead in a ditch near a construction site and had also been shot. About a month later, a tip came into police with the whereabouts of 35-year-old Awana Patton. She, too, had been shot and was found on a dirt road. Hayes is also linked but not charged for another murder around the same time in 2008. At the time, police had discovered a pattern and believed the killer would strike again. Then, the cases went cold. But then, a murder a decade later, the body of another woman who also worked as a prostitute was discovered. This time, the woman had been strangled. Detectives knew Rachel Bay's death and the other 3 shooting deaths were all connected through DNA and ballistics, but couldn't identify the killer. Robert Hayes then came into the picture, and investigators charged him with Rachel Bay's murder. He also became suspect number 1 in the Daytona Beach murders. Officers put Hayes under surveillance. 3 years after Bay's murder, while he was at a bus stop, Hayes dropped a cigarette butt, which changed the course of the investigation. Hayes' DNA linked him to the killings.
We were able to get a DNA profile of an unidentified male. That was entered into CODIS, which is the National DNA Database. In December of 2016, we were returned with a hit from 3 cases in Daytona Beach. That led us to Daytona and speaking with their detectives. This case has been worked nonstop since then. We were able to identify a suspect through people that Daytona had talked with. He lived up in Daytona during their homicides. He lived here during the homicide of Rachel Bay. We were able to identify Robert Tyrone Hayes as our suspect.
For this trial, Hayes faces 3 counts of first-degree murder and sexual battery charges. If convicted, he could face the death penalty. For Law&Crime Daily, I'm Jesse Weber.
The judge in the case has ruled prosecutors can mention Hayes is suspected of killing Rachel Bay, but aren't allowed to say how she was killed. The judge also ruled no one in the case is allowed to refer to Hayes as a serial killer throughout the trial. Once a jury is selected, Law&Crime Network will have gavel-to-gavel coverage from Florida. Legal analyst Kirk Nermy and co-host Terry Austin join us to break down this upcoming trial. Terry, all 3 of Hayes' alleged victims are female sex workers. Why do you think that is, and how does the prosecution use this in the case?
Well, obviously, he targeted these individuals because they're vulnerable. It's easy to pick them up. They are already there and ready, willing, and able to go with someone. And they are often in these desperate financial situations and willing to be with someone. And they're trying to make a living however they can. So he's taking advantage of these women because they are easy targets. And you see, he's discarding the bodies as if they are garbage. I think that the prosecution is going to be able to use this because hopefully they can show that there is a tie between the crimes and that there is a similar motive and similar preparation for these crimes, and they can use that against him. So we'll see what happens.
Yeah. Kirk, unlikely we're going to see video surveillance, unlikely we're going to see someone on the stand say, hey, he did it. It seems that ballistics and DNA link Hayes to these 3 women. What do you anticipate the defense will be in this case?
Right. Well, you know, as somebody who practiced capital defense work for a number of years, I know that job number 1 of a capital defense attorney is to save the client's life. So in a case like this, you have to look at it in a way that they're not necessarily trying to gain the acquittal, but save someone's life. So when we talk about all the DNA, all the links to these three crimes, what we're really going to be talking about in terms of defense is not sowing reasonable doubt, but sowing that just little tiny bit of doubt in hopes that that little bit of doubt will make one juror feel uncomfortable in sentencing Mr. Hayes to death, because that's really the goal, is to obtain a life sentence here, not an acquittal.
Yeah, as the defense usually says, you just need just one juror to say they're unsure or that they're not guilty. It'll be interesting to see how this case plays out and see how the ballistics as well as the DNA points to one person or doesn't. Again, make sure to follow Law and Crime Network for gavel-to-gavel coverage. And another case started a lengthy jury selection process Monday in one of the largest murder cases in Ohio's history. William Husill is a former doctor accused of giving lethal amounts of painkillers to over 24 patients between May 2015 and November of 2018. Husill's attorney, Jose Baez, known for representing several high-profile defendants, including Casey Anthony, says the former doctor was simply providing comfort care for critically ill patients. Husill was initially charged with 25 counts of murder. 11 of those were dismissed last month as prosecutors decided to focus on the patients who received the highest amount of fentanyl. Prosecutors previously said if convicted, Husill can only serve so many life terms and that it was a waste of resources and money to incarcerate a man for more lifetimes than he has. Each of the 14 counts carries a mandatory sentence of 15 years to life if convicted. 900 people were summoned in December for jury duty. Opening statements are expected to start February 22nd. When we come back, a judge-approved no-knock warrant leads to the death of a 22-year-old African-American man. We head to Minnesota for the latest developments in the death of AMIR LOCKE. Welcome back to Law and Crime Daily. 1 week after the death of 22-year-old black man AMIR LOCKE was shot and killed, police arrest LOCKE's cousin, the suspect of the no-knock warrant that was issued. Body camera footage shows what happened last Wednesday when police entered an apartment early that morning. LOCKE was sleeping on the couch at his cousin's apartment. An initial press release from the Minneapolis Police Department stated LOCKE had a handgun pointed at the officers. The video seems to tell a different story. It shows officers entering and announcing their presence after going through the door. An officer then kicks the couch, which prompts LOCKE to wake up. After that, an officer off-screen shot LOCKE. This shooting, as well as others, like the one involving Breonna Taylor in Kentucky, has prompted city council members and Minneapolis Mayor Jacob Frey to discuss no-knock warrant policy within their city.
Prior to November of 2020, there wasn't a no-knock/no-announce warrant policy in the city of Minneapolis. As of November 30th, 2020, our policy reform then required officers to announce their presence and their purpose prior to entry when serving any type of warrant, including a no-knock warrant, barring circumstances that could potentially be dangerous, where there was imminent threat to the public or an individual. Now, the moratorium, which was put in place, I believe, on Friday, that then additionally prevents the requesting of a no-knock, no-announce warrant.
Like back in 2020, why didn't you just like do a full-on ban?
Certainly, we could have said that in all circumstances, you're required to both knock and announce. These are instances where, we could always go further. And I think in this instance, with this policy, we need to.
LOCKE's cousin, 17-year-old Mekhi Speed, was the subject of the original warrant. Speed was arrested Monday and charged with second-degree murder and a January 10th homicide. Kirk, do you think we will see criminal charges in this case for the officers?
Brian, while these actions demonstrate the ills of no-knock warrants and what could happen, we see in this 15-second or so video, the police coming in, storming in, and we see the gun being pulled. And unfortunately, in that period of time, and I understand there might be more body cam footage coming forward, that we don't really see anything where criminal charges can be proffered. I don't see any recklessness, any disregard, some of the things that we've heard about coming out of Minnesota. The only criminal charges I could see is if there's something else in the body cam, or if there was something, a flaw in the warrant, if the evidence in the warrant or supported to get the no-knock warrant was somehow invalid and based on police figure. Other than that, I don't see criminal charges coming out of this case.
Yeah, this may just stay on the civil side. Terry, Mayor Fry has put a moratorium on no-knock warrants unless there's an imminent danger to the public. What do you think the future of no-knock warrants in Minneapolis is?
Well, there have been so many problems in Minneapolis about no-knock warrants and other places in the country as well. And their use should be extremely limited, if at all. I think a moratorium completely may be the way to go. When you see these sort of no-knock warrants, it's really dangerous for both sides of the door. It's dangerous for the police because they're coming in and they could be surprised if someone sees them coming in with the gun, and then immediately that individual is on the defensive. And it's dangerous for the individual, obviously, because they could get shot. So, I mean, I think there are very limited instances if we know that there's a hostage, perhaps. But if their concern is the individual getting away because it's a criminal, they can surround the place. So I think they should be extremely limited or banned.
Yeah, the risks seem to outweigh the benefits, and we'll see how that continues. Thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.